this particular case study example is got what I refer to as a no clause, and there may even be a swear word in there if depending on how colourful you like your language. This one comes up far more regularly than we would like, and normally comes up at a point in the process where if it's not already too late, it's getting very close to being too late. It generally involves a power to vary, which is extremely wide. In fact, it has no prohibition at all as to what the variation might entail. So it can amend the schedule. So unlike Jenkins, it can amend the schedule. It can amend appointor powers, it can amend principal powers, it can amend the vesting day, it can do anything. Okay? Very, very wide power of variation. But invariably, what sometimes happens, and you only get to find this if you've actually read the trust instrument, is this. Towards the end of the document, and I've said in the last 2 or 3 clauses, there's often an unrelated clause. So it can be titled as innocuous as further trustee directions or something very, very nebulous that's put in there. Generally an unrelated clause to the actual power to vary. And it will say buried, the most recent one we had was actually buried in the middle of another sentence dealing with something else, and another paragraph dealing with something else entirely. And it said, notwithstanding anything in this trust instrument, the power of variation may not be used unless, for example, the appointor consents to that power of variation. Now, the reason I've titled that a no clause is that invariably when we discover that, it's when they've been with another advisor over a period of time, they've come to us at a point in process to get some specialist advice, we've applied the mantra that we say is absolute gospel, and that is that we've read the entire trust instrument, realise there's this clause that has a prohibition on variation, and then go back and get the previous variation and go, oh no, that variation doesn't have the consent of the appointor